The emotional toll of a divorce is heavy enough, but the financial unraveling that follows can feel like a second, more complex trauma. You look around at the life you've built, the home you bought together, the retirement accounts you've been funding for decades, the investments, the cars, even the furniture, and the looming question is paralyzing. How will this all be split? The law doesn't see your home as a collection of memories, it sees it as a marital asset with a market value. The process of dividing property in a divorce isn't about fairness in the emotional sense, but about applying a specific legal framework. And that framework varies dramatically depending on one critical factor: where you live today. We're moving past the fear and into clarity. We're going to demystify the two primary legal systems governing property division in the United States, define in concrete terms what is considered yours, theirs, and ours, and explain the key factors courts consider when making those divisions. This isn't legal advice for your specific case, but it is the essential knowledge you need to understand the playing field, communicate effectively with your attorney, and begin to plan for your financial future. The single most important concept to grasp is the legal distinction between marital property and separate property. This is the foundational dividing line. Separate property is, generally, anything you own before the marriage. This includes assets like a bank account in your name alone with premarital funds, a house you purchased solo before saying "I do," or an inheritance left solely to you, even if received during the marriage. The key is that it must be kept separate. If you deposit that inheritance check into a joint checking account used to pay marital bills, it can lose its separate status through a process called commingling. Marital property is essentially everything else acquired during the marriage, regardless of whose name is on the title. Your salaries earned while married. Marital property. The house you bought together after the wedding. Marital property. The 401k contributions you both made from your paychecks over the last 15 years. Marital property. Even debt follows these rules. Credit card debt run up during the marriage for family expenses is typically marital debt, to be divided. Understanding this distinction is the first step in predicting what's on the table for division. Now, the rules for how that marital property is divided depend entirely on whether you live in a community property state or an equitable distribution state. This is the crucial geographical divide. 9 states are community property states: Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. In these states, the law operates on a simple, but strict, principle: all marital property is owned 50/50 by both spouses. Upon divorce, the goal is a near equal, 50/50 split of all community assets and debts. It's a mathematical approach. The vast majority of other states follow the equitable distribution model. Here, the key word is equitable, not equal. The court's goal is a division that is fair and just under the circumstances, which may or may not be a straight 50/50 split. This is where the specifics of your life and marriage become critically important to the outcome. So, in equitable distribution states, what factors make a division fair? Courts have a long list of considerations, and their weight varies. Key factors include: 1. The duration of the marriage. A 25-year marriage will typically see assets divided more evenly than a 3-year marriage. 2. The income and earning capacity of each spouse. If one spouse sacrificed their career to raise children, the court may award them a larger share of assets to compensate for their reduced future earnings. 3. Contributions to the marriage. This isn't just financial. Homemaking, childcare, and supporting the other spouse's education or career are all valued contributions. For the age and health of each spouse, a spouse in poor health or near retirement age may be awarded a greater share for security. 5. Tax consequences. The court may consider the tax implications of awarding certain assets like a retirement account versus a house to one party. Fault, meaning the reasons for the divorce like adultery or abuse, is not a factor in property division in most no-fault divorce states, but it can be in a few jurisdictions. The process is less about simple math and more about a holistic assessment of fairness. Let us apply these principles to the most common and contentious assets, the marital home and retirement accounts. The family home is often the largest asset and the biggest emotional flashpoint. Courts have several options. They can order the home sold and the proceeds split. They can award the home to one spouse, often the primary caregiver of minor children, and offset its value by giving the other spouse more of another asset, like retirement funds, or less commonly, they can order a temporary award until children reach adulthood. Retirement accounts, like 401(k)s and pensions, are marital property to the extent they were funded during the marriage. Dividing them requires a special court order called a QDRO, Qualified Domestic Relations Order. This is a complex legal document that instructs the retirement plan administrator to split the account without triggering early withdrawal penalties or taxes. Failing to properly execute a QDRO is one of the most common and costly post-divorce financial mistakes. Given this complex landscape, your strategic approach matters. Proactive steps and common pitfalls. First, documentation is power. Gather records of all assets and debts from before and during the marriage. Second, understand that valuation is a battlefront. You and your spouse may need appraisers for real estate, businesses, or collectibles. Third, do not hide assets. This is illegal, will destroy your credibility with the court, and can result in you forfeiting your share of that asset. Fourth, and most importantly, hire a competent family law attorney. This is not the area for DIY legal work. A good attorney will help you negotiate a settlement or advocate for you in court, ensuring all factors are presented and all division orders like QDROs are correctly drafted. Mediation or collaborative divorce can often lead to more control and less costly outcomes than a protracted court battle. In conclusion, divorce property division is a legal process of categorization, valuation, and distribution governed by state law. It separates marital from separate property, then applies either a community property near equal or equitable distribution fair, not necessarily equal framework. The outcome hinges on factors like marriage length, contributions, and future needs. Navigating this requires meticulous documentation, professional valuation, and skilled legal guidance. Critical legal disclaimer: this video is for educational and informational purposes only. It is not legal advice. Family law is intensely fact-specific and varies by jurisdiction. The information provided is a general overview and may not reflect the laws in your state or your unique situation. You must consult with a qualified family law attorney in your area for advice regarding your divorce and property division. Do not take any action based solely on the content of this video. Understanding these principles arms you with the knowledge to have informed discussions and make strategic decisions during an undoubtedly difficult time. If this breakdown of property division laws was helpful, please subscribe. Let me know in the comments which asset you think is often the most complicated to divide in a divorce.